Gacaca courts are a traditional system of justice in Rwanda, originally used to resolve conflicts such as land disputes and property damage. They focus on restoring social harmony and reintegrating people who have caused harm back into the community. After the 1994 genocide, Gacaca courts were modified to handle the immense number of genocide-related cases. They aimed to promote reconciliation and national unity by trying suspects, encouraging them to confess and apologize, and uncovering unknown details of the genocide. Critics noted that Gacaca judges often lacked legal experience, leading to inconsistent trial quality, and that the system's expediency compromised fair trial rights. Gacaca Court, traditional system of justice in Rwanda. It was revived and modified in the aftermath of the country's 1994 genocide, during which more than 800,000 civilians, primarily those of the Tutsi ethnic group, were killed. Gacaca courts were one of the means used to bring the many perpetrators of the genocide to justice and to promote reconciliation in the country, though the efficacy of this approach is disputed. Gacaca is a Kinyarwanda word popularly translated as grass that has come to be more broadly translated as justice on the grass, lawn justice, or similar, when referring to Rwanda's traditional justice system, which held proceedings outdoors. In pre-colonial days, Gacaca courts were used to resolve conflicts between families or individuals, typically civil matters such as land disputes, property damage, and succession issues. The Gacaca courts were informal and did not have a rigid structure. Elders, typically heads of households, served as judges, inyangamugayo. The primary focus of these courts was to restore harmony to the community's social order, which included the reintegration back into the community of the person at fault. During Gacaca proceedings, efforts were made to uncover the truth of the matter, encouraging confession. Compensation for the injured party was sometimes recommended. Participating in the Gacaca process and complying with the court's decision was voluntary, though social pressure could be compelling enough to ensure those factors. In the late 19th century, Rwanda fell under colonial administration, first by Germany, then by Belgium, and a Western-style judicial system was imposed. Although this diminished the role that the Gacaca courts held among the Rwandan population, the Gacaca courts did continue to exist and operated alongside the new legal system, with a focus on addressing local needs. After Rwanda's independence in 1962, the Gacaca courts persisted. They gradually gained more formality and structure but still functioned at the local level. Rwanda is home to two primary ethnic groups: the Hutu, which is the largest group, and the Tutsi. A third group, the Twa, constitutes less than 1% of the population. From the mid-20th century on, ethnic tensions between the two main groups erupted periodically, leading to mass killings of the Tutsi minority and the displacement of many more. A large number of Tutsi fled to neighboring Uganda. On October 1, 1990, the Rwandan Civil War began when the Rwandan Patriotic Front, RPF, led by Tutsi who had been in exile in Uganda, launched their liberation struggle and invaded Rwanda, which at the time was governed by longtime President Juvenal Habyarimana, a Hutu. In 1993, a peace and power-sharing agreement was reached between the two sides, but it was opposed by Hutu extremists. They increased the dissemination of their anti-Tutsi propaganda, which had already been widely propagated for a few years via newspapers and radio stations, and plotted to kill the minority Tutsi population as well as anyone who opposed those genocidal intentions. The genocide was put into motion after a plane carrying President Habyarimana was shot down on April 6, 1994. Everyone on board was killed. Over the course of some 100 days in April, July 1994, more than 800,000 civilians, primarily Tutsi, but also moderate Hutu, were killed. Some estimates, including that of the Rwandan government, are higher. It is estimated that some 200,000 Hutu, many of whom were ordinary citizens, spurred on by the steady diet of propaganda from various media outlets and led by Hutu extremist militias, participated in the genocide. It ended when the RPF secured most of the country, including Kigali, the capital, and the extremist Hutu leaders fled. Once the genocide was over, Rwanda faced years of recovery, and the RPF-led government pursued transitional justice. Trying those who were thought to be responsible for genocidal acts was a primary focus, as was promoting reconciliation and national unity, considerable tasks in a country where many genocide survivors were aware that their families had been killed by neighbors or acquaintances. Those accused of participating in the genocide were primarily tried in one of three court systems: the International Criminal Tribunal for Rwanda, ICTR, Rwandan National Courts, or, later, the Gacaca courts. The Gacaca court option arose in the years after the genocide as the enormous scale of Rwanda's justice needs became more apparent. The number of suspects to be tried in connection with the genocide was immense. Rwandan jails were dangerously overcrowded with suspects and rife with human rights violations, and cases moved slowly through the ICTR and national courts. The idea of somehow using the traditional Gacaca justice system gathered steam in 1998 when the Rwandan government began holding meetings to discuss how to address the backlog of more than 100,000 cases. The next year the government announced plans to establish Gacaca courts, albeit modified with more legal structure to hear most genocide-related cases. The decision was not universally supported. Many involved in the government's discussions had reservations about taking this approach. In addition to clearing the backlog of cases, the government hoped that the Gacaca courts would bring to light some of the unknown details of the genocide, provide a sense of closure, and foster reconciliation between Rwandans. The structure, function, and mandate of the reimagined Gacaca courts were provided for by Organic Law 40/2000, which was passed on January 26, 2001, and came into effect later that year. It established a hierarchy of Gacaca courts, beginning with small communities at the most local level, called cells, then sectors, districts, and, at the highest level, provinces. The latter two levels were abolished in 2004 when another law, Organic Law 16/2004, reorganized the hierarchy. The Gacaca courts were authorized to try those suspected of having committed crimes of genocide, crimes against humanity, and other crimes, during the broader armed conflict from October 1, 1990, through December 31, 1994. Crimes were sorted into four categories, ranging from Category 1, which was the most serious and included the criminal acts perpetrated by the organizers of the genocide and other crimes against humanity, see sidebar, offenses included under Category 1, to Category 4, which was for crimes against assets. The number of categories was later reduced to 3 under Organic Law 16/2004. The categories were used to determine the venue in which a suspect would be tried. The most serious crimes were not eligible for a trial in the Gacaca courts, but the far more numerous number of minor crimes were, as well as some capital crimes. The Gacaca courts were overseen by the National Service of Gacaca Jurisdictions, previously the Department of Gacaca Jurisdictions, and were launched on June 18, 2002, with a pilot phase that was later expanded. In all, more than 12,000 Gacaca courts were established. Gacaca judges were chosen from among the local community, and although legal knowledge was not a requirement, judges had to meet other qualifications, including not having a record of participation in the genocide, though many would later be removed from their posts for this reason, the ability to be impartial, and not currently holding public office, which included the police, the military, and the judiciary, or being an official of a political organization. Among the initial duties of the Gacaca courts was to create lists of all the suspected perpetrators within the court's jurisdiction and their offenses. Hundreds of thousands of new cases were found during this exercise. More cases were also added later after trials had started, as courts heard testimony, and more alleged accomplices were named. The Gacaca process operated with an emphasis on encouraging the suspected perpetrators to confess, plead guilty, and apologize for their crimes, and had a formal procedure established to facilitate that outcome. The courts had a detailed schedule outlining the limits of the penalties that could be imposed on a perpetrator that took into account factors such as the category of their crime, if they had testified and if their testimony was found to be truthful, and if they participated in the court's confession and guilty plea procedure. Those that participated in the procedure could have their penalties reduced. There was an appeals process available for certain categories of crimes. At the cell level, Gacaca courts typically met once a week. Community participation in the Gacaca process was mandatory, even those not party to a case were obligated to observe the proceedings. The Gacaca courts were intended to operate for a limited amount of time, but closure of the courts was repeatedly postponed. By the time the Gacaca courts officially closed on June 18, 2012, they had prosecuted more than 1.9 million cases, far more than the national courts and ICTR, and had a conviction rate of 86%. The Gacaca courts were a system of transitional justice in Rwanda following the 1994 genocide. Gacaca, meaning short grass, referred to the public space where neighborhood male elders, abagabo, would meet to solve local problems. The name was chosen in 2001 for the national criminal justice system created in order to try those implicated in the 1994 Rwandan genocide, during which over 1 million people were killed, tortured, and raped. In 1994, the United Nations Security Council created the International Criminal Tribunal for Rwanda to try high-ranking government and army officials accused of genocide, war crimes, and crimes against humanity. Legally established in 2001, the Gacaca courts began conducting trials in 2002 and proliferated throughout the country by early 2007. The Gacaca courts were presented as a method of transitional justice, claimed by the Rwandan government to promote communal healing and rebuilding in the wake of the genocide. The system has received various criticisms. The Survivors Fund, which represents survivors of the genocide, worried the Gacaca courts put survivors in danger of reprisal. Incidents of survivors being targeted for providing evidence at the courts have been detailed in a number of reports. Scholars have shown how the courts became a critical mechanism for establishing the government's official narrative on the genocide, recognizing only Tutsi as victims and Hutu as perpetrators. Natasha Nsabimana, assistant professor of anthropology at the University of Chicago, describes how the Gacaca system reinforced a temporal and social framework she termed genocide time, where genocidal violence in the past is recounted and made agentive in the present through social interactions and choices made by political subjects in their social-political landscape. She contends this perception influences daily interactions and the collective psyche, complicating genuine reconciliation. Furthermore, Nsabimana points out that the official narrative promoted by Gacaca often oversimplifies the complex identities and histories of individuals, grouping them into broad categories of victim and perpetrator, which does not necessarily reflect their lived realities and personal histories. History of Gacaca. Within 17th century Rwanda, prior to colonization, the extended lineage or family, umuryango, which encompassed several households, inzu, was the main unit of social organization within Rwandan society. The status of people within families was based upon the age and sex of the person. Only older married men, without living parents, were independent, while all others, especially women, were to be dependent and subservient to men. The family lineage controlled arranged marriages, ancestral traditions and ceremonies, payment or retrieval of debts, and was the primary source of security. Ruling over these lineages were kings, mwami, presiding over their respective kingdoms. The king, within Rwandan society, embodied power, justice, and knowledge and was responsible for mediating major disputes within his region. However, before disputes were brought to the kings, they were heard locally by wise men in Gacaca gatherings. The name Gacaca is derived from the Kinyarwanda word umukaka, meaning a plant so soft to sit on that people prefer to gather on it. Gacaca gatherings were meant to restore order and harmony within communities by acknowledging wrongs and pursuing justice for the victim. The colonization of Rwanda and introduction of Western law systems transformed Rwandan society, with Rwandans going to westernized courts to settle disputes. As the kings and wise men declined in legitimacy, Gacaca courts began to dwindle. Post-genocide Gacaca. After the genocide, the new Rwandan government struggled to prosecute the approximately 130,000 alleged perpetrators. Originally, they were to be tried in the International Criminal Tribunal for Rwanda, ICTR. Lacking the resources to organize First World courts, the Gacaca system was seen as a means of preventing communities and individuals from seeking revenge. The goal of the Gacaca courts was to establish truth about what happened, accelerate the legal proceedings for those accused of genocide crimes, eradicate the culture of impunity, reconcile Rwandans and reinforce their unity, use the capacities of Rwandan society to deal with its problems through a justice-based Rwandan custom. The categorization of Gacaca courts in Rwanda is based on the concept of a cell and a sector. A cell is equivalent to a small community while a sector is equivalent to a small group of cells making up a village. Within these two categories, there were 9,013 cells and 1,545 sectors, with over 12,103 Gacaca courts established nationwide. Presiding over the Gacaca meetings were inyangamugayo, judges. These judges were elected to serve on a 9-person council. During the Gacaca process, there were two phases. Starting between 2005 and 2006, information was taken from those who were accused from all Gacaca cells. The approximate number of those who were accused was 850,000, 50,000 of which were deceased. The spontaneous emergence of the Gacaca activities and the gradual support for Gacaca by the authorities was motivated by the fact that the ordinary justice system was virtually non-existent after the genocide. The Gacaca had to do what it did before: relieve the pressure on the ordinary law courts, which had worked slowly before the genocide and had ground to a halt during the violence. After the genocide ended and law courts reopened, they were quickly overloaded by the cases of genocide suspects who were filling the prisons. The new Gacaca system was not unprecedented, bearing similarities to Truth and Reconciliation Commissions, TRC. South Africa's TRC bore the slogan "Revealing is Healing" and operated under the belief that truth-telling served as a therapeutic function. Rwandan government heard suggestions to establish its own TRC, but ultimately chose the more historically and culturally familiar Gacaca system. The International Criminal Tribunal for Rwanda, ICTR, established in 1995, operated simultaneously with the Gacaca courts. It has indicted 93 people for crimes committed during the genocide. The United Nations Security Council established the ICTR to prosecute persons responsible for genocide and other serious violations of international humanitarian law committed in the territory of Rwanda and neighbor states, between January 1, 1994 and 31 December 1994. The ICTR is located in Arusha, Tanzania, and has offices in Kigali, Rwanda. Its appeals chamber is located in The Hague, Netherlands. The ICTR has played a pioneering role in the establishment of a credible international criminal justice system and is the first ever international tribunal to deliver verdicts in relation to genocide, and the first to interpret the definition of genocide set forth in the 1948 Geneva Conventions. It also is the first international tribunal to define rape in international criminal law and to recognize rape as a means of perpetrating genocide. The ICTR delivered its last trial judgment on December 20, 2012 in the Ngirabatware case. Following this milestone, the tribunal's remaining judicial work now rests solely with the appeals chamber. As of October 2014, only one case comprising 6 separate appeals is pending before the ICTR appeals chamber. One additional appeal from ICTR trial judgment was delivered in December 2014 in the Ngirabatware case by the appeals chamber of the Mechanism for International Criminal Tribunals, which started assuming responsibility for the ICTR's residual functions on July 1, 2012. The ICTR's formal closure is scheduled to coincide with the return of the appeals chamber's judgment in its last appeal. Until the return of that judgment in 2015, the ICTR will continue its efforts to end impunity for those responsible for the genocide through a combination of judicial, outreach, and capacity-building efforts. Through these efforts, The ICTR will fulfill its mandate of bringing justice to the victims of the genocide and, in the process, hopes to deter others from committing similar atrocities in the future. Successes. Rwanda's experiment in mass community-based justice has been a mixed success. Rwandans are deeply divided on the benefits of Gacaca. Rwandan government supporters, including foreign academics and local Rwandans, claim it has shed light on what happened in their communities during the 100 days of genocide in 1994. Many Rwandans critical of the government see it as a means of distorting the events of 1994 and disseminating lies. Scholars have shown that it became a means of silencing alternative narratives amongst the Rwandan population and effectively worked as a form of show trial. Other scholars praise it for helping families find the bodies of their lost relatives, which could then be properly buried. It has also ensured that tens of thousands of perpetrators were brought to justice. Some Rwandans say that it has helped set in motion reconciliation within their communities. The majority of praise for Gacaca comes from Rwanda's government itself and Rwandans who experienced the system directly. Some of the latter, who were among those most affected by the Rwandan genocide, praise the system for providing a sense of closure, acceptance, and forgiveness after each trial concludes. The Gacaca trials also served to promote reconciliation by providing a means for victims to learn the truth about the death of their family members and relatives. They also gave perpetrators the opportunity to confess their crimes, show remorse, and ask for forgiveness from their community. Criticisms. Legal criticism. The casual format of Gacaca has led to many legal criticisms. Participants lacked numerous rights and privileges common to Western courts. They had no right to know the charges levied against them, no right to a lawyer or the presumption of innocence, no right to be present at their own trial or to request time to prepare their case, and no right against confront witnesses. Furthermore, they had no right against self-incrimination, double jeopardy, or arbitrary arrest and detention. Furthermore, there was vast evidence of corruption among officials. You have to give money. Gacaca judges are not paid, so they make arrangements to get money from those who are accused, said a man accused of genocide who claimed to have bribed the judges. The lack of legal representation is largely a result of the genocide itself, during which the vast majority of legal professionals became victims. The courts would instead rely on unpaid and untrained people of integrity, including some genocide perpetrators, to serve as judges, lawyers, and the jury. Senior Human Rights Watch advisor Alison DeForges said the lack of legal representation was a serious concern. The authorities' view is that this is a quasi-customary kind of procedure, and there never used to be lawyers, so there's no need for lawyers now. The problem with that is that little is the same except for the name. In this system, there is considerable weight given to the official side. The Office of the Prosecutor provides considerable assistance to the bench of judges in terms of making its determination, so you no longer have a level playing field. There may, however, be no alternative to the Gacaca trials, she added. Obviously, the problem of delivering justice after the genocide is an overwhelming problem. Gacaca may not be ideal, but there is at this point no alternative. The official explanation, I think, is that people did not speak openly until the Gacaca process, and now many more accusations are surfacing. Also, the concession program, which requires the naming of all those who participated along with the accused in return for a lighter sentence, has led to a multiplication of names. How many of these are well-founded? What is the credibility of the evidence? These are very serious concerns. There are criticisms and controversy surrounding the decision to implement Gacaca courts. Human rights groups worry about the fairness since trials are held without lawyers, which means that there is less protection for defendants than in conventional courts. In addition, conventional trials have seen false accusations and intimidation of witnesses on both sides. Issues of revenge have been raised as a concern. The acquittal rate has been 20%, which suggests a large number of trials were not well founded. Also, because the trials are based on witnesses' testimonies, the length of time between the crime and trial heightens the risk that the witnesses' memories will be unreliable. Removal of RPF crimes. The government's decision to exclude crimes committed by soldiers of the current ruling party, the RPF, from Gacaca court's jurisdiction has left victims of their crimes still waiting for justice, Human Rights Watch said. Soldiers of the RPF, which ended the genocide in July 1994 and went on to form the current government, killed tens of thousands of people between April and December 1994. In 2004, the Gacaca law was amended to exclude such crimes, and the government worked to ensure that these crimes were not discussed in Gacaca. One of the serious shortcomings of Gacaca has been its failure to provide justice to all victims of serious crimes committed in 1994, Beckiel said. By removing RPF crimes from their jurisdiction, the government limited the potential of the Gacaca courts to foster long-term reconciliation in Rwanda. The biggest problem with Gacaca is the crimes we can't discuss. We're told that certain crimes, those killings by the RPF, cannot be discussed in Gacaca even though the families need to talk. We're told to be quiet on these matters. It's a big problem. It's not justice, said a relative of a victim of crimes by soldiers of the current ruling party. Reconciliation. Though Gacaca was claimed to contribute to reconciliation by the Rwandan government, it functioned fundamentally as a punitive form of justice which many scholars have characterized as retributive in focus rather than reconciliatory in nature. Punishments ranged from forced labor in public works projects, TIG, to life in prison without family visits, special measures. Despite its claimed restorative nature, Gacaca is a legal process, and with this in mind, punishment constitutes a major element of the Gacaca courts. According to official Rwandan government records, the courts had a conviction rate of 86% and tried over 1 million suspects.